in listen-only mode.
Hi, welcome to this webinar on fully developed claims and evidence development. My name is Katie Dwight, and I'm here with Becca von Baren. We are lawyers at Swords to Plowshares, a veteran service organization in San Francisco. Swords to Plowshares provides a range of services to veterans, including legal benefits advocacy, employment and training services, case management for homeless and low-income veterans, and housing, both permanent and transitional. We're going to do this webinar, as I said, on fully developed claims and evidence development, and I'm going to jump right into it now with fully developed claims. The fully developed claims process was designed by the VA to process claims within 30 days. The way that it speeds up the process is by providing the VCAA notice, which is the VA's compliance with the duty to notify veterans. The VCAA notice at Section 5103 is placed in the instructions of the FDC application forms. And the FDC process essentially shifts the burden to the veteran from the VA to obtain certain records. And that burden shifts also to the veteran's representative. After a pilot program, which was deemed successful, they tried it in 10 regional offices and felt that it was a success, and so they took it national, and it is now up and running throughout the country. In order to submit a fully developed claim, you have to use one of the assigned forms. The first one is Form 21-526EZ. This can be used for service-connected claims, and that includes original claims, new claims, reopened claims, secondary claims, and claims for increase. You can also do individual unemployability claim using the 21-526EZ, and you have to submit the 21-8940 with that. You can also use the form to apply for temporary 100% due to hospitalization. You can apply for compensation based on Section 1151, which is medical negligence. And you can put in a claim for increase based on special monthly compensation, aid in attendance, and housebound using Forms 21-2680 or Form 21-0779. Those must be submitted. Also, you can, with the same form, you can apply for specially adapted home or special home adaptation using Form 26-4555, automobile allowance or adaptive equipment using Form 21-4502, and benefits for a helpless child or seriously disabled child on Form 21-686C. You can fill out an application online using VonApp, which when you complete that, it creates a Form 21-526EZ online that is uploaded to Virtual VA. In addition to 21-526, there's there's Form 21-527EZ, and that is mainly used for pension. It can be used for special monthly pension using the forms stated there. It can be used for pension benefits based on helpless or seriously disabled child using Form 21-686C. And then Form 21-534EZ can be used to apply for DIC, accrued benefits, DIC based on Section 1151 or death pension, or increased survivor benefits based on aid, attendance, or housebound, benefits for a helpless or seriously disabled child on Form 21-686C, Each of these forms has a box that can be checked, indicating that the claimant does not want to use the FDC process and is going to submit more evidence. So the easy forms can be used in the standard processing, rather than just the FDC. If an incomplete FDC form is submitted, it will establish an effective date, much like an informal claim, as long as the veteran can be identified from the information that's been provided. On the application, easy application forms are a certification that the veteran must sign off on, and the certification says that they have been truthful in the information provided. It's a release of information so the VA can get records. It's acknowledgement of receipt of the 5103 notice, and it's acknowledgement of that the application is complete and no more evidence is going to be submitted to support the claim. So there's a number of things that can be done that will cause the claim to get booted out of the FDC process. The first one is using forms dated February 2010. That was the version of the form, easy form, that was prior to the present one, and it cannot be used. If you submit a form on that, if you submit a claim on that application form, it will be sent to be processed by the standard process. If you use non-easy forms, you will not get assigned to the FDC process. If you check the box for not wanting the FDC program, then of course you're not going to get put in the FDC process. If you fail to sign an application, that will get you booted. Fail to submit any of the additional forms required to apply for the claimed benefit. This is important because a lot of applications are getting submitted without those additional forms that are required. If you're submitting a claim for individual unemployability, that form has to be attached to the EZ form. Also, if you're submitting a claim for PTSD, you have to have the stressor statement form attached. If you don't do that, the application will be reverted back to standard processing. Also, they will not process character of discharge determination claims. When that is required, they will not process them as fully developed claims. If the claim requires more evidence collection, including private medical records or reserve National Guard records, it will not be processed through FDC. And these records this is sort of the principal difference between FDC and standard processing, is that in standard processing the VA will collect private medical records or reserve National Guard records. The vet just simply has to sign a release of records for the VA to gather those. But under the FDC program, those records will not be gathered by the VA and must be gathered by the veteran or the veteran's representative. If there is further development of any sort that's required beyond obtaining federal records, then the claim will be booted out of FDC. The VA will gather federal records, including Social Security records if necessary, but they will not gather state records or local records. Those must be submitted by the veteran. But what you don't want to do in the FDC, if you're submitting an FDC claim, is submit Form 21-4142, which gives VA a release to obtain private medical records. If you submit that, the VA is going to assume that you want them to gather private medical records, and they will not process it as an FDC. Then there's some things that the veteran can do after submitting the claim that would end up in having the claim put into the standard processing pile. And one would be filing additional evidence, which is not allowed. You have certified in signing the application form that you have submitted all the evidence, and so adding more later is not acceptable for the FDC process. Also, you cannot file another claim while the first claim is pending. If you do that, the first one gets booted. If the veteran fails to show up for the compensation and pension examination, that will be excluded from the FDC program. When the FDC law was put into practice, the VA required the regional offices and pension management centers to institute procedures for processing FDCs. And so in their internal process, within 1 day of receipt of an EZ form, the following is supposed to happen within 1 day. Establish end product control, enter contentions into MAPD as appropriate, attach a paper flash indicating FDC, and drop off the paper folder in the designated FDC location. Within 3 days, the regional office should have requested VA records and federal records, if necessary, and they should request a VA examination and write expedited treatment requested and appreciated, in hopes that that will get the medical center to hurry up in scheduling an exam. The rating activity is directed to make a decision within 10 days of receiving the claim. Whether this happens, I'm highly suspicious. If the claim is excluded from FDC, then these procedures apply. The paper flash is removed. It's noted in MAPD the reason for exclusion. Process the claim using standard processing. Provide notice to the veteran of exclusion from FDC. And provide a Section 5103 notice. A different notice is required when the veteran has submitted a reopened claim. The VA is required to provide notice that that the veteran must provide new and material evidence in order to reopen. But at the same time, the notice advises that although new and material evidence is required, sending additional evidence will take the claim out of the FDC program. So this can be really confusing for veterans. They're just really not sure what it means. They may think that they have to submit new evidence even if they already submitted new and material evidence. They may feel that this means they have to supply more and send in additional evidence, and then they're booted out of the FDC program. So they really need representatives to be able to explain clearly what this notice means. In order to encourage use of the FDC program, the VA has provided a special incentive program, and that is to receive an effective date 1 year prior to filing of the claim. So if the claim is filed on February 14th, 2015, and the claim is approved on May 14th, 2015, the effective date is going to be February 14th, 2014, 1 year before the filing date. This rule applies only, though, to original claims. It does not apply to new claims or claims for increase, reopened claims, only original claims. And it only applies if the veteran is found to have a disability that manifests to 10% from the date a year prior. The veteran must have been separated from active duty more than 1 year ago. Claims excluded from FDC will not receive the favorable retroactive date. And the program runs, it began on August 6, 2013. It runs to August 5th, 2015. And informal claims are not eligible for the retroactive date. It only applies when a easy form is properly submitted. Disability benefits questionnaires is something the VA has been promoting. It's questionnaires on many different conditions that has set questions for medical providers to be able to fill out and provide information and answers to. There's over 70 DBQs. The VA believes that submitting a DBQ is going to help the claim be ready for decision faster because they have all the information that's needed. They're available in an easy form for them to make the quick decision. There are not DBQs available for TBI or initial PTSD exams. DBQs can be taken to private medical providers by veterans. And now I'm going to hand off to Becca, who's going to talk about evidence development.
Hello. So we're going to talk a little bit about how FDC claims shift the burden, the evidentiary burdens to the veteran, and also how you'll want to request records for the veteran as a veteran's advocate. So fully developed claims shift the burden of evidence collection from the VA onto the veteran and the veteran's representative. So VSRs must ensure that all of the required evidence to succeed on the claim is submitted with the fully developed claim when it is submitted. As Katie talked about, if there is further evidence required, the fully developed claim will get bounced back into the regular track. So you definitely want to make sure that all of the evidence is submitted up front. And as Katie also mentioned, the VA isn't going to go out fishing for evidence in a FDC case. So if there's any outside evidence that is going to be needed to establish the veteran's claim, to have a successful claim, that outside evidence must be submitted at the time that the FDC claim is submitted to the VA. So examples of some outside evidence that the VA won't have: a statement from the veteran, statements of friends and family, buddies, witnesses, marriage, birth, death certificates, photos, diary entries, newspaper clippings, medical research, any online research on military units. So for example, if you're filing a DIC claim and you are not attaching the death certificate, which is something that's required for a DIC claim, that's not something, that's outside evidence. That's something the VA won't have. So when you go ahead and submit the easy form, the FDC form, you need to have all of the required outside evidence, such as the death certificate for a DIC claim, attached to that form. Same thing with, as Katie mentioned, with a PTSD claim, you're going to want the stressor statement form attached. You're also going to want, if you want additional evidence that might corroborate the severity of the PTSD, things like that would come from buddy statements or statements from family members, you're going to want that attached. Now, this is especially important with claims that might come from a survivor of military sexual trauma who's trying to establish service-connected post-traumatic stress disorder for service-connected disability compensation. A claim like that requires a lot of outside evidence because the VA accepts outside evidence to corroborate the in-service stressor. You're going to end up with a lot of evidence attached to that claim, and so you're going to want to make sure that you do all that collection up front. Now, your goals when you're gathering the evidence and the records, one thing that's important to keep in mind is do not rely on the VA to obtain the records, and also do not rely on the VA to connect the dots. So if you have records where you're presenting, with the example just used, a claim for PTSD as a result of military sexual trauma, you're going to have a lot of evidence that's corroborating the in-service trauma, and you're going to need to connect those dots for the VA rater. You're going to need to show how all that outside evidence comes together to corroborate the claim. You don't want to just dump the kitchen sink on the rater and expect them to be able to figure out how the evidence comes together to meet the requirements of the regulations. So you're going to want to keep in mind that you can't rely on the VA to obtain the records and connect the dots. Now, some advocates will say, you know, I don't need to present records that are already in the VA's possession, records that are already in the claims file. Now, it's important to review all the evidence and even sometimes present the evidence with your attached to your claim packet that you're submitting to the VA, even though you know the VA has it. And that's because of what we just discussed in terms of connecting the dots for the VA. A claims file might be 3 volumes. And so a rater will be going through, looking at all the records, but may not spot, you know, a particular complaint, you know, one tiny complaint of back pain and service with a complaint of back pain and VA medical records, and some indication of a nexus statement that also appears in the VA medical records, because there's such a large pile of evidence for them to review. So you're going to want to submit those documents, even though the VA already has them, so that you can connect the dots for them. So by clarifying and presenting the evidence in a way that demonstrates a claim's merit, we help the VA, and most importantly, we're helping the veteran. Now, we all know the VA raters are incredibly overworked with the backlog, and that results in frequent mistakes. So presenting a well-developed claim also helps reduce the backlog by streamlining the rater's review, because you're presenting the successful claim for the rater, instead of the rater having to go on a fishing expedition to see if there's any merit to the claim in the 3-volume claims file that's sitting on their desk, not to mention the VA medical records. So in terms of medical records, you're going to want to gather all records yourself, including VA medical records. Now you request VA medical records on VA Form 105345. Now it's really important when you're talking to a veteran about where they receive their treatment that you don't simply request the medical records from the place where they're receiving their treatment. It's important that you specifically ask the veteran, what are all of the different VA medical centers where you've received treatment? Because it may be that the veteran bounced around since their service and they received treatment at a 3 or 4 different VA medical centers since their service. And you're going to want to make sure that you capture all of those records, especially because it can demonstrate continuity of symptoms. So it's always important to ask the veteran where are all of the VA medical centers that you have received treatment, and get them to sign release forms for all of those locations. You're also going to want to request prior compensation and pension exams. And that's important because you're going to learn a lot if a claim was denied and you're with a veteran who's reopening the claim or trying again to service connect that condition. It can be really helpful to read over the prior compensation and pension exam and see what it was that the CMP examiner focused on as the reason for the denial. And compensation and pension exams are becoming more and more difficult to access and request, and that's because they're being conducted by outside contractors more and more frequently. So you used to be able to just, for example, make a request to the San Francisco VA Medical Center for all records, and you would have the prior compensation and pension exams in those records. But now those exams won't be in the medical records because they are held by the contractor instead. And you can't even access them through Capri. So it can take some digging around to access prior compensation and pension exams. Now, medical records, sometimes you'll find some information about a veteran's medical conditions in their personnel records. And what you might find in there would be time that the veteran was on sick leave, things like that, that although it's coming from the personnel record, still indicates an instance of a medical condition, or if they were on light duty. So don't discount searching through the personnel records for information about a veteran's in-service medical history. And obviously you're going to want to request the in-service medical records, and Capri is also a resource for gathering medical records. Now you're also going to want to request any private medical records that a veteran might have. And this could be from in-service. They may have seen a private clinician while they were in service, or it might be post-service. The but that's always an important question to ask, is whether or not the veteran has ever sought private medical care. And when I'm requesting records from a private medical facility, I always call. Some folks will send a generic HIPAA compliant release, but I've had a lot of those releases bounce back to me saying, we have our own form, the veteran will need to fill out this form, this specific form, in order for us to send you records, which then requires the veteran to come back in, sign a new release, etc. So when I'm with a veteran, I always call the facility and ask what their specific procedures are for requesting records. It's always good to have specific dates if the veteran remembers them, but if they don't remember the specific dates, err on the side of being broad. That's always a good idea, especially, even sometimes if a veteran thinks that they remember the exact dates, I might add a month on either side. A lot of the release forms ask you to state the purpose. Why are you requesting these records? And you also want to state the date that the release expires. But there's a little glitch here. Some VA medical centers, even if you state the date that the release expires, which would seem to indicate that you could reuse that request form to keep requesting and updating your collection of records until that release expires. I've actually had some VA medical centers deny my request because it's past the date on which the veteran has dated their signature. So that's a little sticking point with some medical centers, and I'm not sure if that's a misunderstanding, but that's just something to be aware of. Now, for National Guard and reservists, it can be very difficult to track down records. When you look up how to request records, you will find that you must request the records from the state that the veteran served in, from that state's adjutant general. Now, I was assisting a client who was in the National Guard, and we tried every which way to gather their records from the National Guard, and we were not getting any records back, and her claim kept getting denied because there were no records from her National Guard service. She did have some active duty service, but we couldn't get anything from the National Guard. And we kept trying and trying. We tried a whole bunch of different ways and kind of got creative. We sent FOIA requests. We called the Adjutant General's office. We called and spoke to clerical staff. We did a whole bunch of things and made a whole bunch of phone calls, and after about 11 months, we finally got a packet of personnel records and in-service medical records from the National Guard. And those were records that the VA also was not able to acquire. And I'm not sure exactly which phone call it was. It wasn't the FOIA request. It wasn't clear in the cover letter who it was that pushed the magic button, but picking up the phone is always a good idea, because these records can really be hard to track down. So definitely get creative with this one if you can't get it on the first try from the Attorney General. Now, getting service treatment records. Obviously, you're familiar with the SF-180. Now, some of the in-service treatment records, the in-service medical records, are held at the VA Records Management Center. Sometimes they'll be at the National Personnel Records Center, depending on which branch and when the veteran served. But they can also be in the claims file at the VA regional office with jurisdiction over the claim if a claim is pending. So it's sort of a dance trying to get the in-service medical records. If you submit a claim, the VA Records Management Center is going to send the in-service medical records to the VA regional office with jurisdiction over the claim, and those in-service medical records are going to go into the claims file. And once they've gone into the claims file, the only way that you are going to be able to have access to those in-service medical records is by requesting either copies of the claims file from the VA regional office or by requesting to view the claims file in person at the VA regional office. Now, you can request to view the claims file or to get a copy of the claims file using VA Form 3288. But this can be very sort of a race against the clock. Can you submit the claim and a request to the VA Records Management Center at the same time and get the records from the VA Records Management Center before they go to the claims file, because that's a quicker way to get the records than having to go through the claims file. So it's sort of a dance there. But once they're in the claims file, it can take quite a long time to be able to view the in-service medical records. You know, and it also can sometimes hold up the claim, because while you have a FOIA request pending to view the claims file, that claims file is removed from, if an adjudicator would be working on it, it's removed from the queue. So I've had instances where I've checked on the status of a claim and heard back that the claim was on a rater's desk but was pulled because there was a FOIA request for me to view the claims file. So things can get a little sticky there, but those are the different ways of viewing veterans in-service medical records, which of course is crucial to establish the element of the condition stemming from service, or can be crucial. Now, in-service clinical, inpatient, or outpatient records from a military hospital can be difficult in other ways to track down. Now, military hospital records are maintained by the facility where the treatment took place. And then after a certain period of time, they get forwarded to the National Personnel Records Center, and they can either be filed within the individual's records or by the facility. So when you're filling out the SF-180, you're going to obviously want to make the regular request, but when they say other, you would want to put in you know, something along the lines of you know, DeWitt outpatient records from X date to X date, because that alerts the NPRC that they should not only be checking for the records by the individual's identification data, but also by the facility name. The other thing is that you can go along, get a lot of records by requesting the records directly from the facility. So sometimes, you know, there's different, each facility has, as I said, takes, you know, 1 year, 2 years, 5 years, however long, before they retire the records to the NPRC, or sometimes the facilities will actually entirely purge the records, which I don't know if that's policy, but from phone calls with different medical, you know, Department of Defense medical facilities, I have been told that the records were purged and not at the NPRC. So whether that's policy or just practice, I'm not sure. But I have had quite a bit of luck by just calling the, you know, if it's an Army hospital, calling the Army hospital and inquiring about requesting records, where are their records, who's the best person to talk to about it, if their records are no longer on location, where have they gone to. It can be really difficult, however. A lot of military hospitals have been shut down, especially when you're dealing with Vietnam veterans. A lot of the facilities have closed, and that obviously presents problems with getting records. And sometimes they will go to the NPRC. Other times they'll actually be transferred to the facility where that the medical center is being collapsed into. And the best place I've found to look for that is Google. You know, there's a lot of forums about, you know, from other people trying to track down their records. So a little internet research will go a long way for that. And as I said, different branches, medical facilities keep records for different periods of time before either purging them or forwarding them to the NPRC. Now, when you're reviewing medical records, you want to review them very carefully with attention to detail. A lot of times there will be very brief notes from doctors that you might pass over that can go a long way. I just recently reviewed a veteran's medical records for a second time. There was an issue over whether or not the veteran was experiencing PTSD symptoms or symptoms of psychosis. And the doctor made a small note that the symptoms of psychosis were actually very, very heightened re-experiencing symptoms of PTSD. He, in fact, wasn't having auditory and visual hallucinations. He was having very heightened flashbacks where it was sort of a psychosymptomatic hearing and seeing memories of Vietnam, and that little opinion by the doctor really goes a long way in establishing his claim that it is that, you know, the auditory and visual hallucinations are PTSD symptoms. They are not symptoms of psychosis. So I won't go, you know, I won't delve too far into that, but, you know, it took me two reviews to catch that. Now, I'm not suggesting that you have to review all medical records twice, but you know, really catching those little things can go a long way. The other thing is Google is your friend. If you come across a word or an acronym or something like that that you don't recognize, don't just skim over it. Flip to Google, type it in, you know, go to a medical dictionary, see what it is. Because again, you can skip over some really important information just by not knowing what an abbreviation means. So that can be really important also. Obviously, know any diagnoses, any symptoms. And for each condition that you come across, read the diagnostic code and look in current medical records for evidence that aligns with the diagnostic code. And when you're submitting an application, highlight the evidence that's favorable to the veteran and attach the favorable evidence to the application. And that gets back to what I mentioned before with stacks and stacks of records on the rater's desk. You know, if I'm talking about advocates carefully reviewing records, with the amount of claims that raters have to view every day, you know, a nice, neat application with the evidence attached and the diagnoses highlighted, etc., is going to make the rater's job a lot easier, and it's going to make the chances of success on the claim much higher. Now, military personnel records, so the in-service personnel records. Most of those, except for we covered National Guard and reservists, are located at the National Personnel Record Center. Now, you can get records expedited for homeless veterans. One thing is you may have to do follow-up requests to the National Personnel Record Center. I've actually had productions come back from the NPRC that are about a half a centimeter, and mostly, you know, duplicate documents, and simply sent a fax back with Sharpie on it saying insufficient production, please produce again, and have gotten back a production that was about an inch thick. I have no idea what happens behind the curtain there, but doing a follow-up request can be beneficial. Also, it's important to read that cover letter that comes with an NPRC production, because some of the cover letters will actually say, we have provided these documents if available, but if you are interested in these other documents, you must make a follow-up request. So, it's easy to skip over those cover letters because, we all see them so often. But read the cover letter and see if you've gotten one of those that indicates that a follow-up request could be necessary. Military personnel records can also be at the Human Resources of Personnel Command of the branch. As I said, the State Adjutant General of the state in which the veteran served for National Guard and Reservists. And it's always a good idea to request the claims file because the VA might have records that you can't locate elsewhere. And you can request military unit histories from the locations that are on the screen. And for unit histories for classified informations, you can get it from the U.S. Army Joint Services Records Research Center. And again, that information is on the screen. And you can also submit FOIA requests for classified info and military unit histories to the Defense Logistics Agency. And that contact information is on the screen. And again, there's a lot on Google. There are a lot of group pages where people have forums. There's just a ton of information available online. I've also had clients who, really needed a buddy statement to corroborate something that happened, and they were able to find them on Facebook. They hadn't seen them in 40 years, but found them on Facebook, were able to contact them and get a buddy statement. So make good use of the internet. It can also be a really good idea to attach medical evidence to a veteran's claim to help substantiate assertions that you're making in the claim. So that could be from medical treatises, medical dictionaries, the DSM, or other sources of reliable information. I wouldn't suggest Wikipedia necessarily, but verifiable, the National Institute of Health, the American Psychiatric Association. One thing it can be good for example, is establishing perhaps that misconduct is, or, acts of violence or substance use is commonly symptomatic of post-traumatic stress disorder. The National Center for PTSD has a lot of information about what symptoms are correlated with PTSD. And if you're doing a character of discharge application where where a service member was booted out for misconduct, and the misconduct was substance use, medical evidence from the National Center for PTSD showing that substance use is a common symptom of PTSD can be really helpful in backing up what would otherwise be just your own lay statement that's a common symptom, because you're always going to want to back up your assertions and your arguments with actual evidence. Now I'm going to talk a little bit about writing effective stressor statements. So good statements from buddies or from the veteran can really influence the rater. It can make them feel a personal interest in the case, and it can also increase their level of compassion for the veteran. And that can be very important because the raters review a lot of claims, and having a claim where they feel a personal investment or get a sense of personality from what's on paper can make the difference between a case that they spend 5 more minutes on versus a case that they spend that just sort of flip through quickly. Now, as advocates, there are two ways that to obtain a stressor statement, and choosing which mode to use really depends on the veteran's ability to talk about their stressor. You know, to what level do they get triggered when they talk about their stressor, how difficult it is for them, or how difficult is it for them to write in the first place or to piece together a narrative. So some veterans can write it on their own, although it's always a good idea to review it before submission. Just a quick example, I had a veteran write their stressor statement, and the amount of expletives outweighed the other words in the statement, so I suggested perhaps taking some of them out would be a good idea. So a little review never hurts. The other method is to have the veteran tell their story, and while they tell their story, you can take notes and then turn your notes into a written narrative using the veteran's own words and their own voice as much as possible. And then obviously have the veteran review for accuracy and any edits, additions, or deletions they would like to make before submission. Now, personal statements, and this could be a personal statement that would be used for a character of discharge determination, a discharge upgrade, a personal statement to go along with a PTSD application. This slide is particularly tailored to a personal statement that would go along with demonstrating the severity of a veteran's PTSD symptoms. But you're going to want the personal statement to be presented in chronological order so that it's easy for the rater to read. You're going to want to have the veteran present as much detail as possible. And the veteran's going to want to describe their mental state prior to service, their mental state during combat, and their mental state after returning home up to the present. And what that establishes is the degree of difference between the person that they were prior to enlistment versus the person they've become after combat. And that can really help a rater in determining the percentage that they'll award. And then you're going to want to have the veteran describe their current symptoms of PTSD and how they affect the veteran's daily life. And what I mean by the veteran's daily life are things such as how it affects their employment, do they use substances, how does it affect their relationships, do they engage in risk-seeking behaviors, what's their mood like, do they have suicidal ideations, and again, this gets to assisting the rater in assigning a percentage. Now you're going to want to conclude personal statements with the following language. I certify under penalty of perjury that the foregoing statement is true and correct to the best of my knowledge and belief. Now, family and friend statements, these are really important sources of information because family and friends observe the veteran. And they can really witness changes in the veteran that even the veteran themselves might not notice. So the family and friend statements can be very important. And they can verify a physical injury as well as a psychiatric condition. Again, it's going to want to be, the statement should be presented in chronological order, showing the veteran prior to the injury, be it moral injury or physical injury, before any indication or news of the injury they received or heard of during service, letters home, etc., or if they didn't, just before and after. It's going to want to contain as much detail as possible and conclude with the same declaration that we covered in the last slide. And statements in support of claims work to persuade the rater why they should grant the case, and they should refer to favorable evidence. Now, the format, you're going to want an introduction, which simply identifies the benefit being sought. You're going to want to be clear. Don't let the rater get halfway through your present, the packet of information before they even know what you're asking for. Right up front, let them know what benefit the veteran is seeking. Then have a section that presents a statement of the facts. Describe the in-service injury and describe the current injury or disease or disability. And that shouldn't be a novel, keep that brief, but try to put in, detail at the same time. Dates if you know them, keep it detailed in the sense of, if the injury happened on a ship, I was at this place on the ship, we were docked here, etc. Keep it accurate and detailed, but don't try not to make it too long at the same time. And then you have the discussion, and you're going to want to start the discussion with a clear statement of the rules that apply for that particular kind of claim to be successful. And then you're going to want to state how the veteran fulfills those requirements. And you're going to want to attach evidence to back up those assertions. So if you state the veteran has a current diagnosis of PTSD, attach a medical record that shows a diagnosis of PTSD, highlight the diagnosis, and say, see attachment A for diagnosis, or something along those lines. Make it easy for the rater, and make sure that you're backing up every assertion you make. And then you're going to want to explain why ambiguous or even harmful evidence should be viewed in the veteran's favor. So for example, what I was talking about earlier with the veteran, where there was confusion as to whether hearing voices and having images of the war sort of be present with him, there was confusion as to whether those were symptoms of psychosis or post-traumatic stress. Explain that, take that doctor's explanation and explain, quote it, say, these are not signs that he has psychosis. These are actually signs of the extreme severity of his PTSD. As noted by Dr. Such and Such, it's extremely heightened re-experiencing behavior and flashbacks. Please see attached medical record, highlight it, attach it to the packet. So that's the format that you should be following, and you should have a conclusion which clearly restates what do you want the rater to do. Keep it short. Don't conclude with recapping your argument. Don't conclude with sort of a bleeding heart, personalized conclusion, just a restatement of what you want the rater to do. And then you'll have your attachments, the medical records, the statements, the medical articles, and treatises. So thank you so much for joining us for this presentation, and I hope that you were able to learn a lot. Thank you.